Hi, everyone. Welcome to another episode of the Ask Amity Show. My name is Edmund. I'm here with my two partners, Jennifer and Cindy. We're the attorneys here at Amity Law Group in Rosemead, California. One of the topics that we wanted to discuss today, and we get this question a lot, is how do I protect my son or my daughter's inheritance from their spouse? So a lot of parents these days, especially since divorce rates are still relatively high in our society, they want to protect what they leave their children from their potential ex-wives and ex-husbands. So in the event that they divorce, their ex-spouse won't run away with half of the inheritance that you've left your children. So what can you do to make sure that that doesn't happen? And so today, Jennifer is going to talk about the inheritance laws that is related to this topic. And then Cindy is going to show us some of the practical ways to make sure that you protect your children's inheritance.
So typically in California, any assets that you receive through inheritance is actually considered your separate property. So if you're able to source the ways you receive this asset as an inheritance, it's technically your separate property. But if you commingle that asset, whereas you either add your spouse's name on that particular asset, or you somehow make that asset into something that's something that's between husband and wife, that's what we call commingling. That will raise kind of issues later on down the road if there is a potential for divorce, because it'll make it less clear as to where those assets came from. So for instance, if you were to receive a house from a parent and you title the house as, let's say for instance, for myself, Jennifer, and husband as husband and wife, then you sort of commingle that because you added your spouse's name on the title, on the deed. But if I were to receive that house and I title it as Jennifer, just by myself, then I can still somehow prove that when I initially received this property, it was via an inheritance or through a trust. So that will maintain that property as a separate property. Same thing with bank accounts. If you were to add your spouse's name when you receive a cash inheritance, then it's harder to prove that it's separate because both your names are on the title or on the bank account. So based on California law, inheritance is separate property, but you have to somehow maintain it so that it's clear in case there is a divorce, how to prove that it was sourced from an inheritance. So Cindy can go into more detail as to kind of the practical ways to maintain those as separate property.
Yeah, so the first thing you want to do once you receive an inheritance or a gift is to make sure that you keep detailed records and notes about those gifts and those inheritance. If you're a mom trying to give money to a son, make sure that there's a trail, and it says maybe you give it in a check form, and you write only his name. Okay, don't write to son and daughter-in-law, because now it's a gift to both of them. So if you want to make sure that it only goes to your child, you only name your child in that check. So check is really one of the best ways because there's a paper trail to it. If you're doing like a wire, make sure that you wire it directly to an account only in their name. So that makes it clear that the intention is you're giving it to your child alone and not to a joint account with him and his spouse. And then if they inherit a house, make sure that your name is titled only in your name. So if you're the child, it's only in the child's name. It's, child as his sole and separate property, or son as his sole and separate property, or daughter as her sole and separate property. Even though they're married, you don't want to say as a married person, you want to say as their sole and separate property. So, and then a third thing you want to make sure that you can try and consider doing is have the spouse record a quitclaim. If it's a property that they own, that you've given your child, and that child is married, you know, it might be a touchy subject, but something worth considering if they're willing to do so is to sign a quitclaim deed and have that recorded against the property, so that evidence that shows that they have waived any interest in that property.
Thank you, Cindy. So as you can see, there's a lot of moving parts and a lot of details that you should be aware of when you're leaving an inheritance for your children to make sure that it's protected in the event that they divorce their spouse. So we go into a lot of these details with our clients when we work with them. And so if you have any questions, we do offer free consultations, and we would love to see how we can help your family. If you have any questions that you'd like us to answer, you can leave it in the comments below. And I think that's it for this video. So take care, continue to stay safe during this pandemic, and we'll see you in the next video.